to see it and hear it later. So you can always, so let's go ahead and get started. So today's topic is lease issues during this pandemic. And what I'm hearing and seeing is that a lot of people, a lot of small businesses that have rental space are already stressed about what's going on with the economy. And as an added layer, they're having to deal with some landlord lease issues. And as I'm fielding these calls and talking to them, I'm realizing that there's so many different situations that are going on at the same time. And so I want to preface this by saying that we are not going to have all the answers today because it's too new. There's too many things that are coming about that we just don't have any definitive guidance as to what this is going to look like. But for some of you, we do. So I just wanted to preface that. I'm going to go ahead and introduce myself while Mary is still trying to get on. My name is Laurie Lee. So for those of you who don't know me already, I'm a local business attorney here in Jacksonville, Florida. My firm is called the Legal Department for Service Professionals. And we serve small businesses, less than 20 employees, under 10 million in revenues, that provide services. And it ranges from all over the place. Many of our clients have brick and mortar facilities. Many of our clients are just purely online. So it depends on the business model. And so on my part of how this is all playing out is that I'm usually the one that is negotiating the leases and reviewing the leases before people sign them. So of course, when clients and small businesses are having problems with their landlords, I often get those calls because they're calling to ask, what do I do about this situation? And one of the things that I want to make sure we're very clear on is that if you have a written lease, and I'm hoping that you do, all of the answers are going to depend on that lease agreement. So it's very important what that lease agreement says, which is one of the reasons why that upfront before you sign is the most critical moment of the lease experience. Because now that you've signed, that's the lease that's going to control what happens right now. But I think what we really wanted to give you a taste for and kind of help you answer some questions around is what happens in certain circumstances that are unanticipated. And what if the lease doesn't really say exactly how you're supposed to handle some of these things? So I know we still don't have Mary, and I know she's probably sitting there pulling her hair out, trying to join us. And I want to go ahead and see if I can help her out for a minute here. And okay, she's logging in. So I'm going to give her a few more minutes and she's logging in. All right, so I want to introduce you to Mary. Mary Scott is not only a friend, she's a fellow attorney in the community here. She's been practicing business litigation since 2003. We actually joined the bar at the same time. She graduated from Tulane School of Law in New Orleans. So she's originally from Louisiana, and you'll hear a little bit of her accent, but she says, don't ask her anything about the Napoleonic Code because that's some crazy voodoo. She represents mostly small and medium-sized businesses. Her practice areas are business litigation and real estate litigation, which is one of the reasons why I've asked her to come on today. Her office is in Ponte Vedra, but she does represent businesses throughout the state of Florida, and she handles both sides of the dispute. So she represents businesses and landlords, and she has a really good perspective in that manner because she's advising from both sides. So while we're waiting for her to get on, we want to make sure that we do our very lawyerly disclaimer, and that for landlords and tenants, it is important to note that your written lease agreement does control. So whatever we say today is for general information purposes and general guidance. Remember that your specific situation might be a little bit different depending on your lease agreement. So I want to start today and kind of give a little bit of background for things I'm hearing, and I want to get some of your input on what you're experiencing this. If it says, if you cannot hear, what is the call-in number? Let me see if I can find that for you very quickly. If you go to the registration email that you should have received, the call-in number is there. So check the registration email. The phone number is there. Success. And there she is. Do you have your mic on, Mary, so we can hear you? Yep, she's going to get set up. Fantastic. Okay, so here's what I'm hearing. I'm getting calls, and I think I told you my whole perspective on this is from the front end, right? Once we get to the point of being in litigation, that's when Mary steps in, and I think I hear her. Hi, Mary.
Hey, can you hear me?
We can hear you. Look at us, two lawyers.
Can you hear me?
The issues. I mean, how crazy is that?
That's what you get. That's what I get for having a Mac at home and a PC at the office. I don't know.
It's like, don't ask us to do math or technology because law school doesn't cover that.
Yeah, this is on tenant and landlord issues, right? Not technology.
Exactly.
Okay,
so don't call us if you need help with technology.
No.
All right. Well, good. So I was just giving them, I know you were kind of listening in, and I just want to give you, give them some insight as to why I reached out to you and called you. And, I'm getting these phone calls in all these different situations, and it goes everywhere from, this is what I'm hearing. And I want you to jump in and say what you're hearing from the small business community. So I have tenants that are in, space where the landlord is really working with them, like I have some clients that are in space with Publix. I don't know if you've read, but Publix has been a really great landlord and has given some rent abatement and deferrals. There's been several other landlords that have come up in the news, and even ones that haven't come up in the news, where they're really working with their small business clients and saying, either we're going to give you an abatement, and here's the difference in words here. So an abatement means that you don't have to pay it back. A deferment means that you don't have to pay it now, but you're going to have to pay it later. So the difference in those two terms is important because you have to kind of budget in what you're seeing. So, I want to get this in here early because really most of what we're talking about today is going to be around landlords who are not working with their small business clients. The ones who I'm going to consider, in my professional opinion, as being unreasonable. I don't want to give any implication that all landlords are doing this. Obviously, if landlords are working with small business clients, then they don't need our help because the landlords are helping them. Right now, we're really trying to help the small businesses where the landlords are not helping them. And that's really the important piece, because all of us as small businesses, the revenue issues are one thing, but then when you have lease obligations, which are contracts, and some of those contracts are really important and have certain consequences, that can be an additional stress and financial burden. So let's talk about this. What are you seeing with on your end from the litigation side? Have you seen anybody filing evictions yet for commercial tenants?
Not really. And in fact, in preparation for this webinar, I asked my assistant to call kind of our local counties, so Duval, St. John's, and Nassau, to find out. Laurie, you and I had talked, and I know Duval had told me they're not serving any evictions or foreclosures right now, but they didn't say that is specific to residential or commercial. And so I had my assistant call back and to find that out. And sure enough, they said, no, it's only residential. Commercial is still going forward. But when you call to ask, they don't make that distinction. But they said they are still allowing people to file commercial evictions. Same thing with St. Johns County. Nassau County said they really didn't know. They said, you could file it and see what happens. And so that's not really why we're trying to do this. But they said they just haven't had any. They said, we don't know. We haven't had anyone try to file. since this has happened. So I mean, from what I've seen, I don't think there are a lot of commercial evictions being filed right now, but I don't know, that may be in the works, because I know you and I have talked, and business owners are getting those notices or getting demand letters. So the landlords are getting lawyers involved. And so it's looking like that might be coming, which, what I represent both landlords and tenants. I work on both ends of these issues. And, for the landlords out there, it just doesn't make sense to evict your tenants right now. I mean, that's not helping the landlord either. The landlord needs money to pay their mortgage and so that they can operate. But if your tenant doesn't have the money to pay you, going through the legal proceeding to kick them out and trying to get a money judgment against them when they don't have any money anyway is not going to get the landlord what they need. It's not going to solve the problem of cash flow. And then what's the next step? You evict the tenant, but now that space is empty.
I'm going to interrupt you for just a second. I'm going to interrupt you for just a second, Mary, because I'm getting some emails or some text chats here. Can I see if we can adjust your microphone, because some people aren't hearing you?
Oh.
Can you go to where your screen is at the bottom? There should be a little microphone icon. There should be a video icon, a microphone icon, and then a gear. Do you see that?
No, that's not it. Yes.
Okay, so there's a little microphone gear. If you can click on that, it'll pop up some options, and then it'll say microphone, and it should have.
No, it didn't. So I see I'm sorry. Sorry to everybody. When it comes to technology.
Okay, see the gear at the bottom of your screen, at the bottom of the screen, that little round gear. That's the one I want you to click.
Oh, gotcha. Okay.
And does it say use microphone on, then it says default, and then it might have another one? Click on the other one, and let's see if that works.
Okay. Is this better?
Can you guys hear her now? Speak again, Marion. Let's see.
So what I was saying before is that better? From the landlord's perspective, it doesn't make sense to be squeezing your tenants, right? Having flow issues as a result of this pandemic that we are all dealing with, especially, tenants that you've had for years who are good tenants, solid tenants, but for what, we're experiencing here across the whole globe that everyone's dealing with. And so what the landlords need to consider is, yes, in a lot of these cases, you could evict your tenant and you can go through the legal process of trying to, getting a money judgment against them, but that doesn't solve the problem for the landlord either, because now that space is empty. The tenant couldn't pay you monthly. They're definitely not going to be able to pay your large money judgment. And now you're trying to rent the space to somebody else. And I don't think businesses are looking right now to expand. So, while the landlords may be frustrated with this situation, I mean, I think we're all very frustrated, and the better option, even if they have the right to squeeze the tenants, is really to try to get something worked out where the landlord's getting some money in and the tenant is not having to pay the full amount right now while they're having these major cash flow issues and can't operate their business. I mean, if not to be, I'm a litigator, so not to be kumbaya and all that, but this is a time to work together, because we all need the same thing. We have to help each other.
Absolutely. And we're going to unpack all of what Mary just said. So that was a fantastic summary of the whole scenario. So let's just step back and look at it just from the landlord's perspective, because whenever you're talking about a situation where there might be a disagreement or a disconnect between parties, let's look at the other side for just a second. So like you said, landlords have this commercial property. Most of the time, they have their own expenses. So unless you're in a triple net lease where you're paying property taxes and utilities and you're paying everything, insurance, landlords usually have some additional costs. So a lot of these buildings for professionals and strip malls and things, they may have common area maintenance costs. They probably have mortgage payments, right? They might not own the property outright, so they're having to pay their bank's payments. So what's happening is that landlords are feeling this pressure to make their payments. But what I'm and before I go to the next thing, so they're then also pressuring the tenants because they're relying on the income from the rent. Okay, we get that. What we're seeing, though, what's really starting to bother me is that these mortgage companies, the banks that the landlords owe money to, are giving deferments to the landlords. So the landlords don't have to make their mortgage payments, but they're not necessarily passing on those breaks to the tenants. So, to me, this seems a little bit, well, I'm just going to keep it clean. I think that, if they're getting a break from their banks, they should be passing that break on to the tenants. So let's understand that the landlords have their own set of issues that they have to deal with. And each situation is different depending on what the landlord owes, if their banks are giving them mortgage breaks, all of that stuff. Mm-hmm. So we understand where they're coming from. Flip it around now, and let's talk about from the small business side. So the small businesses have signed a lease, and most of the time, tenants are required to sign personal guarantees. So it's not only your business entity that's on the lease, you've signed a personal guarantees, which says that if your business doesn't pay the rent, you have to personally. And so what we're seeing now is, a reduction in some revenues. We've actually seen, people shut down from government orders, and even some restaurants that have and other places that have not necessarily completely shut down. They've had a significant reduction in their ability to do business through no fault of their own. So let's first distinguish between, I'm going to say the old way of doing things, where a tenant just decided they were done, or they just decided I don't want to pay rent, or through their own actions, their business is not succeeding very well and they can't pay rent. So that's what we normally see day to day. But now we have this piece now where it's beyond the business's control. So it's not like I'm making bad business decisions and my business has stopped making so much money, or I've just decided I don't want to pay rent. I want to use that money on something else. Or I've decided that I just want to go out of business because I don't want to do this anymore. There's an actual reason beyond everyone's control, so that that kind of comes into play here. So it's not like anyone's a bad actor necessarily. That we don't have any like bad tenants just choosing not to fulfill their contractual obligations. So it's going to be interesting, I think, and you and I have talked about this before, how this starts to play out. And I told everybody before you logged in, we're not going to have the absolute definitive answers on these things just because it's a brand new situation and we're not exactly sure how it's going to play out. But I want to kind of go over a couple things that I think it's important for people to understand about their leases themselves, the lease and what kind of options they may have. And then we're going to take some questions from people too. So go ahead and type your questions in here. I do see them coming. So it says, how could I apply this to resident apartment rentals as a tenant who hasn't been paid in weeks? They are threatening eviction next month. So residential tenancies, that's a good question. Let's get this out of the way first. Right. Residentials are treated different than commercial, right?
Yes. They have a different set of Florida statutes that cover residential. That's going to be different. So, but I will say that residential evictions are not being served right now. So if you file, they may allow landlords to file the cases, but they're not issuing summons, which means the case isn't going anywhere. It may be able to be filed, but they won't be able to serve you. So at least locally, Duval, St. John's, and Nassau, no residential evictions right now.
Right. So, and that's a good point to make right now, because we are just talking about business tenants. and residentials will have their own set of rules. All right, so then we have, yes, Slayman Enterprises is also rolled out a rent deferment program as well. Is it required by law that if the landlord gets mortgage relief, they have to offer the tenant rent relief? No, there is nothing right now. And, there's definitely people who are looking at this issue. We want to bring it to the attention of some policy makers and decision makers that this could be happening. And even if it's not happening, how do we give the tenants the bargaining power that they may need to bring the landlord to the table to say, look, this is something you need to discuss with us. You can't just bring down the hammer. Mm-hmm. So while I'm on it, I don't want to forget to say this. If any of you are on live today, or if you're listening to this afterwards, and you are in a situation where your landlord is not working with you and you would be willing to share your story, we have lots and lots of people who are looking at this issue, not only locally, but statewide, and would love to hear the exact facts about what you're dealing with so that perhaps there could be some big rollout, as a policy. Maybe if it's not a law, maybe it's an executive order, maybe whatever it might be, that could help with some small tenants facing these situations. So please, if you are willing, please email me or Mary and let us know. If we have some time a little bit later, I'm going to bring this topic back up and we'll talk about it further. I want to make sure we get through everybody's questions first. What about lease purchase contracts for small trucking companies? That is a completely different bucket. So I consider different areas of the law buckets. And depending on the bucket you choose, the bucket comes with all the rules. So the bucket we're talking about is property, real estate, property tenants. The bucket you're talking about is leasing of equipment, which is a completely different set of rules. So that one won't apply to anything we say here. Could you make sure to address the dangers of tenants telling landlords they won't be paying rent? Anticipatory breach. Let me see, I lost that. Anticipatory breach as opposed to approaching landlords about working something out jointly. Fantastic, Chris. Mm-hmm. Our fellow colleague Chris Hand is on here. I want to see if I can make Chris a speaker so that he can articulate this. Let's see, Chris, if I can unmute you. If you can unmute yourself, can you hear us? Okay, we can't hear you. Chris, if you've got a... All right, we're not able to hear you, Chris. I tried to unmute you a little bit, but I'll go ahead. If you are open, if you want to speak, I believe you have got the ability to, if we can figure out how to make that happen. But in the meantime, I want to elaborate a little bit about Chris's comment and question, because I think that's important. So tell us a little bit about this anticipatory breach thing.
So, Laurie, are you asking me or is Chris?
Yeah, I don't hear Chris. So Mary, go ahead and jump in until we get him on.
So a couple of things. I mean, anticipatory breach. Broad swope is something when you're in a contractual relationship. Let's back it up. Not talking about leases, and one party to the contract notifies the other party or gives the other party reason to believe that they're not going to be able to fulfill the terms of the contract. Sometimes that allows for the party who is performing the contract, when they know the other party may not be, to go ahead and take action on that anticipated breach of the contract. In this situation, I would say I wouldn't be so concerned about an anticipated breach argument or a landlord thinking because you're struggling, as you're not able to operate your business due to the pandemic, and you might be breaching your duty to pay under the lease. I would say I'm not so concerned about that with the current global pandemic circumstances we're dealing with. I would err on the side of saying to tenants to be proactive and to notify your landlord. I think it's better to risk the landlord knowing what you're going through and reaching out to them and trying to work something out and get ahead of that so that the landlord knows where you're coming from. I mean, when you're dealing in disputes really of any kind, it's I find silence to be very frustrating, and it's hard to work with somebody who's got their head in the sand or who's silent, who is just non-responsive. I think when you're dealing with a party, even when you're on adverse sides, if you're able to communicate on some level, I think that gets you a good ways with the other side. And I think in this situation, tenants being if your landlord's not reaching out to you and asking how you're doing and if you need some sort of relief under the lease, then I think it's okay for the tenant to reach out to the landlord, especially if you've been, you're a good tenant, like Laurie said earlier. You want to be working. You were making money before all this happened, and you intend to make it again. But right now we've got this issue, no fault of the tenant, and it's no sign that your business isn't a good business. You just, there's only so much that we can do here. And so your landlord knows all of that, and they should appreciate it and respect it, and they should want you to stay a tenant because your business is a good one. So I'd say be proactive, reach out to your landlord, see if they're willing to work something out with you for the next few months. Let them know if you've applied for some of these loans and you're waiting to get that, let them know that, hey, I've applied for this. I expect to get this money. So money's coming in, rather than just ignoring the landlord's calls, or their letters and just hoping you get your money and then you can pay them. I lean more on communicate and just let the landlord know your situation, because you're better off if you can head off those kinds of issues by communication rather than not doing anything. You think you're going to get your money or you think you're going to get back on your feet, but in the meantime, the landlord's not getting anything from you, and then all of a sudden you get served with an eviction notice. And
I'm hearing that from a lot of landlords' attorneys are telling me that, look, we'd work with them if they just reached out to us and said, hey, what's going on? I think I want to draw the distinction, though, and I think this is where Chris might be going, and that is calling your landlord and saying, I'm not paying, versus calling your landlord and saying, look, I'm having a hard time. Can you work with me? Right. And I think that approach is a little bit worthy of talking about and saying that, I'm having a hard time. Can you give me a deferment? Can you give me an abatement? Can you help me out in some way? Versus just dropping it and saying, I'm not paying. Anticipatory breach is more like, before the deadline that you have to pay, you call and say, I'm not paying. That could trigger the landlord to have some ability to do some things even before the deadline. So if your rent's due May 1st and you've called them on April 15th and said, I'm not paying May 1st, then, they could go ahead and send out some default letters and start the whole process if they wanted to, right? I mean, isn't that what the whole deadline thing is?
You're right. I wasn't thinking about it in those terms. Correct. I mean, when I say communicate with your landlord, I don't mean communicate, hey, I'm just not going to pay and good luck with all of that. No, I think, what you've got, it's got to be a give and take, because the landlords have responsibilities too. And certainly for landlords, going to your mortgage company or your utility company or going to the people that you pay and you owe to try to get some relief is a really good way to, so that landlords are easing up their responsibility at the same time they're going to ease it on the tenants. But tenants got to understand that landlords do have their expenses. So if tenants can pay some money, it's better than not paying anything. And so that's what I mean to, if you can work something out with your landlord and it shows good faith, right? Because that's the situation where a tenant calls up and say, I'm having these cash flow issues. I can't operate my business, or I'm operating at 20%. But I can give you X amount on X day, I will give you what I can. Can you work with me? Can we figure something out? Is different from a few days before the rent's due saying, I just don't have it. I'm not going to pay you. And you may not have it. And that's one thing if you don't, but still talk to the landlord, because you may be able to come up with a way to get something to them, which shows them you want to continue this relationship. You value the space that you rent and you want to be there. And so you're going to part with some of that, with some cash that you have, which it's hard to come by right now, but you're going to give the landlord what you can. That's better than what they're getting if they evict you, which is paper judgment and no money coming in. So, you kind of got to give the landlord something to hold on to. And I think that's how you get, that your chances are going to be better that they'll work with you if you're willing to give them something.
And I think there's a question in here too, that we've got somebody whose landlord's asking for a gesture of good faith on their rent we owe. And I think that's exactly what you're talking about is, landlords are in their own position. And so sometimes, if they can just see that you're trying, they're willing to kind of come forward and meet you a little bit. But if they don't feel that you're trying, or if they don't see that you're trying because you're not communicating with them,
right,
then they're not going to be willing to come forward and meet with you right? Because you got to kind of see both people moving forward a little bit to see what you can get, a deal with. And if nobody's moving on this side, this one's not going to start moving on that side.
And that, Laurie,
you there? I can hear you. Did I lose you?
And Laurie, if I didn't say, because this came to mind, because this is a really good point. Silence is the biggest enemy, because here's what happens in a lot of these are the kind of things that I see. The landlord doesn't get the tenant's rent. We all know that there's this pandemic going on. And so the tenant may feel like the landlord's just going to assume, well, I couldn't pay it. They know my business is closed. They know I'm not in the building. And so they have, I don't know. I don't have the money. There's nothing I can do about it. And the landlord keeps trying to get in touch with them and the tenant ignores it. Then what happens? Well, then the landlord goes to a lawyer and goes to a litigator and says, hey, my tenant's not responding to any of my demands. I'm willing to work with them. I don't necessarily want to evict them, but they're not responding. I think if I send a letter on a lawyer's letterhead, they're going to respond. Well, and now you got the lawyer fees, because most likely under your lease, the landlord's going to be entitled to get their fees. So now you're going to start owing that, where really it may be that the only thing the landlord wanted was to have a conversation about what's going on and to see if there's a way to get some money in. And, maybe they will, give you a break. Like we talked about, we'll go back over it at some point here, because we want to know the difference between deferment and abatement. So you understand the language that the landlords are speaking about. But, I think just having that communication, and it maybe you can't work it out. Sure. You may not have the funds to get the landlord to work with you for the next few months, but I think trying to have that conversation is better than not, because like I said, that's how the landlords end up in a lawyer's office, and then you get the formal letter.
And I know saying this, it seems so simple, right? It seems, well, just reach out and talk to them. But what I'm seeing, and maybe some people on here are feeling the same way, is that, small businesses, they get nervous. They get nervous, and they're like, oh, you automatically assume that the landlord's going to say no. Yeah. Or that you're going to automatically get in trouble because you're bringing this to the attention, and you just want to kind of ignore it and hope it goes away. But the problem is that, and we want to make sure everyone realizes this now, and that's why we're kind of spending so much time on this. We're going to move on in a minute, but it is really, really important that you show the landlord that you're coming forward, so that the landlord has the ability to come forward too. I mean, I've seen many, lawyer demand letters right now because the tenants are silent, and the landlord's trying to get the tenant to kind of come forward and speak and talk to them. So they have them, like you said, lawyer letter comes, and it just kind of escalates really quickly. And once it starts escalating and people start incurring lawyers' fees, it's much more difficult to come to an agreement. Whereas if you just kind of come in at the beginning, or even now, and just say, hey, can we talk, please? Can we come on a call and just talk about this? I want to tell you what I'm facing, and let's see what you can do for us. And I want to tell you a quick story about one of the clients we have, keeping anonymous and confidential and everything. So this client, it's a female, she got on really early, like back in mid-March, and told her landlord, look, this is the issue I'm facing. And her landlord worked with her for April. Then she got on at the middle of April, and said, this is what I'm still facing, because they were shut down. couldn't open at all. And so got another deferment for May. Again, landlord's saying deferment, but the landlord's not giving any indication as to if the landlord knows the difference between a deferment or abatement, or like when that's going to come back. So, so now what she's looking at is, even when the economy starts opening on Monday, if she were to open back up, and she probably will, she's not allowed to have the volume of people in her space that she had before. So if she could, let's just say, I don't want to give away what kind of business this is, but let's just say she could have 100 people in her business before all this. And now she can only have 30 at a time. I mean,
that's 30 people even want to go to the business.
Right, exactly. And so now, she's had a 70% decrease even after opening. She's had a 70% decrease in the amount of revenues, even if she's at the top of her game. Like if she's full out booked, nobody else can come in all hours of the opening day, she's still sitting at a 70% reduction in revenues. And so, it's not like it's going to be an immediate thing. So even if you haven't talked to your landlord yet, or even if your landlord's come to you and said, hey, we're going to do this deferment, this is the time to call them and say, this is what I'm looking at. I've done the calculations, and even after we open the economy back up and I can open my doors and allow people to come back in, this is the number of seats I have for restaurant. This is the number of seats I have for whatever type of business you have, where people have to come in to get your services. So, showing the landlord the numbers and saying, even if I was at 100% capacity, this is still the reduction I'm facing. And I think, and I don't have a crystal ball, although I pretend I do, I don't think that landlords are going to be able to maintain that, it's all going to pop back up and be rosy, really soon. Because I think even after the economy is opening back up, some of these businesses aren't going to pop back up to normal. So it's not too late to reach out to your landlords and make sure that they understand, because keeping in mind, we're all in our own heads here. I'm looking at my situation, you're looking at your situation. The landlord isn't necessarily looking at it from your eyes. If you can help them see it from your eyes, that helps them better understand where you are, and that you're not just trying to bail out, peace out, I'm not going to take care of my responsibilities.
Right. So
I think that that's an important point that I want to take in mind. I want to see if there's another question. I think we've got some here. I don't want to fall behind. Let's see. Force majeure. Oh, good question. So force majeure is, for those of you who don't know, it's a term of art, what I call magic language, force majeure. Mary, why don't you tell us what it is?
So this is sort of like circumstances outside of the control of the parties to the contract, but that's a really broad definition of it. And I bet every lease has one of these clauses, and I bet most of them are slightly different from the other. And what we're facing here with this pandemic is, I was thinking about that before getting on the webinar today, and I was thinking about force majeure, or like acts of God. We know about hurricanes. We've been through that. There's a lot of history in the courts on that with Florida, of course, but this pandemic is a little different. While it's outside of the control of both parties to the lease agreement, this is general. Of course, I guess we said before, disclaimer, read your lease agreement. Your lease terms are going to govern your relationship. But I don't know that a pandemic really falls under a force majeure, an act of God, which I think more of like a storm kind of a situation. It's more, the building is destroyed due to no fault of the landlord or an accident. And so the space can't be used because of this act of God or this force majeure.
And you're right. I mean, a lot of it depends on the actual language in the force majeure, because, I've read probably over 200 leases in my 17 years of practicing, and they're all different. So some of them say, if they're really specific and they have this, like this and this and this and this, and that's all that's included, then it's a very narrow clause and you probably can't use it. if it says something like, or other circumstances beyond the reasonable control of either party, then that's a pretty broad provision, and then it might be available to you. If you don't have a force majeure clause written into your lease, I would find that hard to believe. I would say that I guess it's possible. Anything's possible. I don't think I've ever seen a lease that doesn't have it. It might be called something different. So if you're looking for the words force majeure, then you might not see those words, but basically what the provision says, and it might just say inability to perform. Sometimes it says excused performance or non-performance or something like that. But basically what you're looking for is a paragraph that says, hey, look, if something happens, if this happens, this happens, this happens, then we're all excused, or whoever's, prevented from performing is excused, because it's beyond their control. That's what you're looking for. And that would be called your force majeure clause. Okay. So I think that's important. And I think, like Mary said, this is so, I hate the word unprecedented because everyone's using it, but it's so unusual because I think we're going to start seeing these arguments come into the courts once the courts start opening up, and maybe some of these cases are getting to the point where they're filing for eviction or something like that. I think we'll probably see these arguments. I think, we've seen some creative arguments already in the press about eminent domain. And thank you, Chris Hand, for sending me that JBJ article about one of our local restaurateurs trying to use eminent domain, saying that I'm a restaurant, I've been shut down by the government, and therefore it's a taking. I think that's a creative argument. I think we all agree he's got an uphill battle to make that argument, but we'll watch it and see what happens. I mean, maybe the courts are open to different interpretations now because it is a different circumstance. And we just don't know what those are going to be because it hasn't happened. Those cases haven't gone before the courts yet, right?
Laurie, can I ask you something on that? I don't want to interrupt.
Sure.
So another thing that I was thinking of is, about that article we read with the eminent domain, and I don't know how that's going to shake out exactly, but again, that's another clause that's going to be in a lot of leases, or maybe it may even be part of the force majeure clause, but leases a lot of times will contemplate a taking. And there's the way that the parties deal with it may already be set out in the agreement. And I want to ask you, Laurie, on the transactional end of this,
I love where you're going.
There may be something about takings, but I don't think in any of those leases would it have been contemplated that would be used in this situation. But that doesn't mean it's not something that is available. Do you mind talking a little bit about?
Yeah, that's a good point. I hadn't thought about that, Mary. I mean, how many eminent domain provisions that I've read in leases, and most of the good leases have this provision that says, if the government comes and says we've got to tear down our building because we're building a road, or the government comes and says, we need to build a power plant right here and we're taking the property, the government pays for that. So the government says, here's money. Now move out of our way because we've got to make this project happen. So it's definitely a different scenario than the one we're dealing with. What's interesting that you just brought up is that I have seen some really loose lease language about this before, where they haven't necessarily defined eminent domain as a true government taking. It's more of like, the government says we have to do this, and therefore here's, you've got so many days to say if you want to stay, or if the property's completely taken, then you can cancel the lease within so many days. I mean, depending on how tightly that language is drafted, somebody as smart as you could drive a bulldozer truck through that language all over town and be able to say, with a straight face and legitimate arguments that, the tenant should be off the hook because we're following the language of the lease. Maybe it wasn't intended for this purpose, but we're using it for this purpose because it fits and it's there, and that's the lease language. But I think the important part is that, and your point over and over again is very good, is that the lease language is so critical here, because we can talk about all kinds of different scenarios, but there's very few laws like statutes that govern commercial tenancies. There's a lot of statutes that govern residential tenancies, but commercial businesses, the law says, look, you guys, you're sophisticated enough to be in business. We're going to let you just have at it. We don't feel like you needed as much protection as, other people who aren't as sophisticated as you. And so, that whole rules that you set up for yourselves are in the lease. And so, my rules are different than, probably your rules for your tenant or, for your lease in your space too. Mm-hmm. So thank you for bringing that up. I'm going to go back and look at that and see if I can find some language for that. But it would only apply to those people. So if it's not in your lease, it wouldn't.
Right.
Here's an interesting one that I'm not sure we would know the answer to. Tenant has been evicted, quote unquote, but not officially because the landlord is telling us they need to be out. But they can't make it to clear out their store due to health mandates. So what are their rights versus the landlord's rights? Ooh, that's a tricky one.
Ooh, okay. So the landlord has told the tenant they want to take back possession of the leased premises. We're assuming because the tenant is not able to pay based on the current issues we're facing with the pandemic. I don't know. I'm not sure if this is happening in this situation because the tenant is not able. They don't think they're going to be able to keep their business, and so they're agreeing to vacate the premises, or if the landlord is just really being stern on this.
Hard to say
because we don't know which way this is.
But I think let's bring it a little bit more general. Maybe it would be applicable. If you do have a landlord that's saying, you need to get out. You're not paying. I'm evicting you. Get out.
Okay.
Is that really how it works? The landlord just tells you to get out?
Yes and no. I mean, the tenant does have rights there. Okay. So the landlord has to give you notice that and I will say, typically, again, your lease might say otherwise, your lease would govern. Typically, a landlord can post a 3-day or send a 3-day notice to a tenant, which gives them 3 business days to get out of the property. Otherwise, the landlord can move forward with eviction proceedings. Now, that the tenant decides that it's going to take longer than 3 days to get out, or they don't abide by that notice, there's not really much difference in what's going to happen from the expiration of that 3 days. And once the landlord files the suit. So the way it works is you get typically a 3-day notice to pay or vacate the premises. If you don't do that, if you don't comply, then typically you will be served with a summary proceeding lawsuit, which means you'll have 5 days to respond to the lawsuit. Generally, the only way you can raise any defenses is if you deposit. This assumes that the breach is non-payment. I'm sorry, this is for non-payment. If that's the reason that the landlord is evicting you, it's a little different if it's something else, but that's most likely the scenario we're going to be dealing with right now. So you have 5 days to deposit the past due rent with the registry of the court. That secures your ability to defend the lawsuit. If you're not able to deposit the money with the registry of the court, which is also probably the situation we're dealing with here, because this is all about cash flow issues.
And the courts are closed.
Well, that is true too. I mean, you can. So I'm being told you can file these commercial evictions. You can get a summons issued, although I think it is slower. So that 5 days, from the time the case is filed, a summons gets issued, it gets served. We're working with some more days. So I guess the short answer to this question, I'm sorry I started going on a rant, but the short answer, realistically, you're going to have more than 3 days. Unless your landlord is telling you, if you're out in this 3-day period, then I will release you from any further liability under the lease. If that were the case, I would be doing everything I can to get my personal property moved out, get that place broom swept clean, and get out of there and say, okay, I'll make this happen, because there's a give and take there. I mean, if
they say I'll release you from liability, because
I will release you from any liability, because the reality of it is, if they don't say that, they give you this 3-day notice. You bust your hump to get all your stuff out, and you're able to find movers who will move your things and break social distancing or what have you right now. I believe that the landlord's end game isn't just to get you out. I have a feeling that you will still face a lawsuit for the rent that's owed, past due, and going forward until they can relet the space. So if that's what the landlord's going to do, then I don't know that I would really be all that concerned about getting out in 3 days if you're just going to sue me anyway. And, then you might as well, you need to get out, and it's a very stressful scenario. So certainly you want to make those arrangements, but what is the landlord can't self-help. So the landlord can't go over there and take your things and put them on the curb. The landlord can't lock the premises with your stuff in there. The landlord has to get relief from the court to do any of those actions. But under normal circumstances where the courts are operating fully, a landlord is able to very quickly file their complaint for eviction, get a summons issued, serve you 5 days later, have a court hearing, and if you don't post that money, they can move for a final judgment of possession of the premises. A writ gets issued by the court. They give it to the sheriff, and the sheriff gives you about 24 hours to get your stuff out.
Okay, so I think that answers the next question too, because it says, can a lawyer send an eviction by email? It says, can a lawyer send an eviction by email? So that's a no. Yes, proper paperwork has to be issued from the court. Let's see. Let me see here. New retail store.
Wait, Laurie, if I might, let me just real quick.
Sure.
Disclaimer. If your lease says that tenant waives all regular rights of notification and agrees that notice by email at such and such address is valid notice for any purposes under the lease, then possibly that notice would be sufficient. But you can't serve by email. You can't serve an eviction by email under the law generally, but I suppose there could be some part of a lease agreement where the parties have
allowed you to do that.
Allowed you to do that. I would find that to be unusual. That's the only that they wouldn't have to do anything else, but I suppose it's possible.
Yeah. And again, your lease is going to control first and foremost before these kind of general rules happen. Mm-hmm. All right. So we've got a question here about PPP. I'm not sure exactly I understand the question. Relief sought, did you get an award? Another email. Okay, so it looks like her landlord is asking if she's applied for PPP, if she's doesn't qualify for PPP, and they're asking for different tax returns, and they've now given her an offer. If you agree, we will drop an amendment. Yes, that's definitely needed. Anytime you change your lease terms, that has to be in writing and signed by both parties. Emails, don't rely on emails. That's a good thing to talk about right now. So it looks like they're offering to defer her rent, and I think any kind of offer is good to take a look at. I'm not sure what your question is, Sunny. So if you want to pop in a question there, it sounds like from your comment, it sounds like that the landlord's working with you on a deferral, and maybe they're willing to kind of spread those payments out over time, and that's usually what a deferral means. So definitely talk to it. If you're brand new, I think what's happening is you might not have the business stability yet that maybe gives you those numbers. I'm not exactly what your question is. So Sunny, if you can type in a question for me that's a little bit differently worded, that would help.
Laurie?
Yeah.
Laurie, can we just real quick go over one thing that you just said that I think is really, really important? I don't want to make sure everybody heard it. You said make sure you get an amendment in writing, and that's something I want to talk. So we're talking about trying to work, both sides working together. Let's see if we can work something out. but everybody does need to understand that I'm pretty sure all of the leases, I'd be surprised to find one that didn't have a clause in there that says that any change to the terms of the lease must be in writing and signed by both sides. So where a landlord says, sure, I'm going to work, we have a good relationship. I'm going to work with you. You're a nice guy. You're a nice gal. Let's, just send me an email writing, letting me know that, confirming the terms that we've worked out for the next 3 months. That's not necessarily something that is enforceable if it's not in writing and signed by both sides. So while it's nice to work together, and I think that's beneficial, we need to make sure that people understand what they need to get from their landlord if they really want to be able to rely on the agreement for a period of months to have some sort of deferment or abatement in the rent.
Mm-hmm. And I'll be honest with you, sometimes I'm not seeing that from some of my clients' landlords. And it might just be because they're so overwhelmed, like some of these bigger landlords do have a lot of tenants they're dealing with. It could just be in the works. So, right. As long as it gets done, that's a good thing. And make sure you talk to your landlord about getting that in writing. And, even if you wanted to write something up yourself and send it to your landlord, says, right, landlord agrees. Yeah, it doesn't have to be fancy or lawyerly, just type it up in a Word document, landlord, identify the landlord, identify yourself, saying we've agreed that now I'm not going to pay rent for this month, and I'm going to pay, half month's rent next month. You sign it, send it to the landlord to sign, and that'd be fine. That'd be enough.
Right.
If you wanted to do that yourself.
That would work.
All right. So I'm looking through here. There was a question here. Is it possible to renegotiate leases, particularly if we can only operate at 25% capacity after reopening? This is something that I'm talking to a lot of people about because we just don't know what those numbers are going to look like. And this is another reason why it's so important. If you've got particular situation Chris Hand, if you're still with us, I'd like for you to join us momentarily to kind of talk about this too. This is why it's so important for people to hear your stories and to hear that, this is your situation, because they need specific facts to be able to make these bigger policy decisions for whether or not there should be additional help for leases for small businesses that maybe can't open to full capacity even after the economy's back up and running. So if it looks like that, you'd be willing to kind of share your story, and if you'd be willing to share it publicly, that would be best. But even if you're just willing to share it kind of off the record, so to speak, and give some details, that would be very, very helpful. And if Chris is still on, I've asked him to join us because, okay, there he is. Hi, Chris. Can you hear us? We can't hear you yet. Are you there? Hi, Chris. Can you hear us? Okay. Well, he's Chris. When you're able to pop in, so you can talk about this. But I think that is the best way we can kind of answer some more of these questions is to be getting these situations out there so that people can understand what's actually happening. So once people start opening back up, you can say, there's no way I can reach this level. And I absolutely think you need to go back and talk to your landlord and try to renegotiate that. That's step number one. Absolutely. Chris, are you with us? Nope. Okay. So that, they can see, like what I was saying, let them see it through your own eyes so that they can understand where you are.
Laurie, can I say something on that too?
Sure.
And one thing that I definitely applaud you and Chris for working on is really, this webinar is going beyond everybody that's watching this. I know you and Chris are working on the legislator end or the government end of this to try to draw attention to this issue before it becomes a big problem. And the way to do that is through real life stories of what's going on. And I think if enough attention is brought to that, hopefully the government will step in. You look at like what happened in 2008 mortgage crisis. It took a little while, but the government did step in to the legal process and started to require certain things in foreclosures that slowed down the process, that really gave the homeowners some additional rights and benefits. And I think that the same would happen here if we do, and hopefully we don't, but if we do start to see a lot of commercial evictions over the fallout from the pandemic. And it is an issue. It's something that people aren't able to control. I do think that the government would step in if they need to, and possibly put in place some additional provisions and things that landlords might need to do if they want to pursue these evictions. That would give some relief to the tenants, or some extra time, or something like that. So I think it is really, really important that we get out that what is really going on here with businesses.
And time is critical, because if small businesses can't survive as long unless they have sufficient working capital in the bank. So really critical. Chris, are you there?
Can you hear me?
Yes. Hi.
There we go.
Thank you for joining us.
There we go. Isn't technology fun?
Yeah,
and,
three lawyers trying to figure out technology.
Well, and thank you both for the really fantastic information you're providing today. I wanted to just briefly, if I might, reinforce a point that both of you have made, and Mary was just saying, which is the great importance of reaching out and sharing stories, but also making sure that the elected officials who are making these decisions and trying to provide for not only COVID emergency orders, but now reopening orders and plans, understand some of these issues. My practice is entirely devoted to government and kind of working with clients to help them navigate governmental opportunities and solve governmental challenges. So I work on these kinds of issues a lot. And one of the best things that all of us can do, let's not forget what the most important title in American democracy is: citizen. And all of us have citizenship skills that we can use to help move government in our direction. So, one of the things I would strongly recommend, and I can provide a link to some resources I've put on my LinkedIn page if that would be helpful. But one of the things I would really recommend is be in touch with your elected officials about these concerns. Now, remember, if you put anything in writing to them, that is most likely going to be a public record. So if you have any concerns about doing that, you may want to try and communicate verbally. But if you're comfortable providing even, general information in writing and comfortable with that being a public record, I always just like to make sure people remember that disclaimer. But, every level of government is working on this right now. At the federal level, of course, as you know, they've now passed 3 COVID-19 relief bills. Congress comes back into session next week. They're going to be considering a 4th one. A lot of that has been aimed at directing financial assistance to individuals, to businesses. Laurie and Mary talked about the PPP and the EIDL, but also to state and local governments and other entities. So federal government has been very focused on the financial picture because of some greater resources that the federal level has as opposed to state and local governments. State and local governments have been much more focused on the day-to-day operations of businesses, who can be open, what social distancing rules apply. And as you probably know, the last 24 hours have seen an incredible amount of activity in that. Yesterday afternoon, Governor DeSantis announced his, I think what's called step-by-step plan for reopening Florida's economy. And as of next Monday, as has already been alluded to here in this webinar, restaurants and retail businesses can start to reopen, but only at 25% capacity. And then, they'll analyze that step and see if they can take another one after that. Here in Jacksonville, Mayor Curry, and he, using his emergency powers, much like the governor has announced that beaches will be open from 6 a.m. to 8 p.m. starting next Monday, only for exercise. Hotels and lodging establishments can start taking reservations again as of next Monday, again, abiding by social distancing rules. So you'll see there's a lot of activity happening. And that's why I think it's even more important now that all of us take this opportunity to use those citizenship skills to be in touch with our elected officials and let them know about these issues that are going on so they can address them in emergency or reopening orders as necessary, or if they can't be done through those emergency powers, through legislation. The Jacksonville City Council is still meeting, albeit via Zoom, but is still passing legislation. And while the state legislature has not met since the end of session in March, I think it is very likely they will do so in the next 45 to 60 days. So being in touch with elected officials, and again, I'll post on the chat page here kind of a link to how you can access some of those resources going forward. The other thing I just wanted to mention real quick is, for those folks who are looking for ways to help generate cash flow during these very difficult times, so much attention has been on the federal programs like the PPP and the EIDL, and for good reason. But I did just want to mention a couple of others while we're on the subject of figuring out how to manage cash flow that may have not gotten as much attention but could be very helpful. One is the Federal Reserve, the Fed, our nation's central banking system, has what's called the Main Street Lending Program. Again, if people go to my LinkedIn page, you'll see an update there that relates to that, but that is particularly geared towards sort of larger small businesses and medium-sized businesses to help provide credit during this time. Something that I think eligible businesses have looked at with the PPP and the EIDL having some funding issues. Of course, some of that money has been replenished, but there still are a lot of people looking for help. And the city of Jacksonville has a number of programs. Jacksonville has been very forward-looking in trying to help small businesses. They partnered with ViStar Credit Union on a small business lending program that had a number of people apply. Now the city of Jacksonville is offering essentially grants, $1,000 grants to people with incomes of less than $75,000. They're just rolling that program out now. So again, I'll share some of these resources, but again, I think important to know what some of the different resources are, but also important that we communicate with elected officials to let them know what some of the challenges are so we can help them craft solutions to that. And the challenges of businesses struggling with their commercial leases has got to be very high on the list of challenges that state and local governments can help deal with.
Thank you, Chris. Excellent information. And again, you said you have all that on your LinkedIn profile, right? So people can find that on your page.
I'll post those so people can find them. Yes.
Fantastic. Thank you so much for sharing that information. And I, Chris and I are trying to figure out, Mary is helping, and a couple of other people are also chipping in to see what we can do, legislatively, or through some form of government action that would help small businesses. So if you would be willing to share your story, I've put my email in the chat. Please just let me know, and we'll reach out to you and talk about it. Or if you're just wanting to know what that would look like, reach out to us and we'll let you know. Couple more things. I know we got a late start. So Mary, are you okay if we continue? And Chris, please stay on too if you want to jump in and answer some of these questions. Are you okay to spend another 10 minutes with us?
Sure.
Okay, great. Because I know there's a couple things I wanted to cover. And that is, what happens if everything hits the fan? What happens if you've tried to work with your landlord? Let's say that, things happen and before any government takes action to help you, and your landlord's not coming through and not making anything, and you're not getting the PPP money or the EIDL money, or you did and it's just not enough, and everything's hit the fan, and now you're facing, what happens? I mean, is the landlord going to evict people?
Well, well, there are a couple things. So from the tenant's end, on what you were just describing, if your landlord's not able to work with you, or if your landlord is not working with you, if you're not able to get back to operating at a capacity that allows you to catch up and pay your bills, if everything is really, the walls are really closing in, you've tried pretty much everything, you're not getting the money that you applied for, or what have you, I'd say kind of the last step, and not, this may not be a last step. This is, let's say this is an option, because I never want to discourage anyone from looking at all of their options. And while there may be a negative connotation to this, there shouldn't be, and that is bankruptcy. It's a tool. It's there for situations like this. It doesn't mean that you are a bad person or a bad business, and it doesn't necessarily mean that you have no money either. There are different types of bankruptcy. And I know that's not what this webinar is on. I'm not going to go into it too much. And I also, I do some bankruptcy work on the creditor's end, but I'm not a bankruptcy attorney. So, but I do think it is important to note the issue of bankruptcy in talking about this, because if you file for bankruptcy protection, what will happen immediately is that any action against you will stop. It freezes everything. So while that would freeze an eviction, any issues you're having with your landlord, though, I mean, it's a big step, and it is a big consideration. And I would certainly suggest talking to a bankruptcy lawyer, not trying to do it yourself. I don't know if you can even file for bankruptcy without a lawyer. If you're a company, you can't represent yourself in court, so that probably includes bankruptcy. But there are a couple of different kinds of bankruptcy. It's not just throwing in the towel liquidation. There's also a reorganization bankruptcy. So if it is something where the walls are closing in, you just can't get caught up, but you don't really think you're in the position where you should just shut your business down and do something else. Reorganization bankruptcy might be a good solution for you. And in a liquidation, if you just unfortunately you've got to shut down, and the COVID-19 pandemic has just really destroyed your business, it may be worth talking to a bankruptcy attorney about liquidation, so that you're not ending up with all of these judgments and all this legal process. I mean, there are ramifications of filing bankruptcy and your credit and all of that, but there are the similar ramifications if you're not able to pay your bills and you just get all these judgments entered against you. And so bankruptcy is an option, and it doesn't necessarily mean the death of your company. It doesn't have to mean that.
That's a good point. And I think a lot of people know about bankruptcy. They don't know exactly what that means.
Right.
And they might think that that's their only option. And I know when you were prefacing this, you said maybe your last option. And I tend to look at bankruptcy as a last option. I tend to try to negotiate with people first, because like you said, bankruptcy is a big deal. It's a big deal. It has lasting implications and consequences. So I 100% agree. You don't just jump into bankruptcy from the very beginning. You kind of work your way to the point where, okay, this is one of my last options, and I need to consider it. So you're right. They definitely need to consider that's an option for them. So landlords can still evict. That's one of the questions that we're getting. Yes, they can.
Yes, they can.
And if that happens and you've signed a personal guarantee, and they evict you, it doesn't necessarily mean that gives you don't have to pay rent anymore, because the landlord signed a contract. So if you've signed a 5-year contract and you're at the end of year 3, okay, and you've paid rent all the way up to your end of year 3, you've got 2 years left. The landlord has the right to get that 2 years of rent, unless they can rent it out again. So they don't get double rent for the same property. But if no one else is coming in, and frankly, in this economy, there may not be a lot of people coming in. Who knows? Hopefully it'll bounce back. But in the event that there's not a whole lot of rush of businesses moving back into some spaces, it could be that the landlord isn't able to relet the premises. And, does that mean that the tenant is, responsible for that last 2 years of rent, even if they evict you?
Most times it does. There is an option where landlords simply retake possession of the premises and convert it to whatever they want to do with it, and then you're off the hook. But let's be honest, most are not going to do that, and that's not a knock on landlords. That the landlords have their bills to pay too. I mean, that typically there's going to be a mortgage and and other operating expenses with the premises. So that's right, Laurie. The first step is that the landlord's probably going to take back the premises and get the tenant out, and the landlord will have a duty to try to relet it. But if they can't, and we're being honest, it's going to be hard to do right now. People aren't able to pay for the space they're in, much less get a new space. So the tenant's going to be responsible for those payments as they become due, or more than likely, again, we're going back to the terms of your lease. More than likely, there's a term in your lease that in the event of default, including a payment default, the landlord's entitled to accelerate the balance of the lease. And then the way that would work is if they are able to relet the space, then you would get some money back. But just because you get evicted doesn't mean that you don't owe anything more to the landlord, unfortunately.
Yeah, and so those personal guarantees are really critical for looking at that, because you personally now are responsible for it, not just your business. So that's critical.
Laurie, can I say something about the personal guarantee, though?
Sure.
I just want to say this, just to I handle cases on both sides. So sometimes I'm on the landlord, sometimes on the tenant, sometimes I'm a creditor, sometimes I represent people who owe money. But I do want to give some, if I can, comfort, if I can, on this. If you happen to be a business owner who's struggling right now with these issues we're talking about, and you did sign a personal guarantee, if you are married and your spouse is not on the personal guarantee, it's just you, you may be able to breathe a little easy, in that it's likely that most of your assets are probably owned by you and your spouse as the marriage, which they call tenants by the entirety. I think in Florida, it's still presumed if you're married that it's tenants by the entirety, unless that changed in the last couple of years. But if your spouse is not on the lease, then the landlord's not going to be able to pursue your spouse or any assets owned by your spouse or owned by you and your spouse as a marital unit. So, and the other thing is, in Florida, we have a really I don't know how to say. We've got a very wide net of homestead exemption. So if you own your home and it is homestead protected, typically your creditors that aren't involved in any improvements to your house, so of course that wouldn't be your landlord, are not able to touch your house, your homestead. So if you ended up being pursued by the landlord and you ended up with a money judgment against you personally on the guarantee, I would not lose sleep over something happening with your house as a result of that, or something happening to property that's owned by you and your spouse. If you and your spouse are on your car title, then I wouldn't worry about your landlord executing on their judgment and coming and taking your car. So, I mean, it's stressful having a personal guarantee out there, but there are certain protections that the state of Florida allows. Homestead and the marital entity are both good ones in that scenario.
Good, all good points. And reminds me that when I am negotiating personal guarantees, when we're negotiating leases, I do notice the really savvy landlords always ask for the personal guarantee of the spouse as well. So
it's very hard not to have the spouse sign on
exactly.
That's why they do it.
So couple questions here I want to, and then we're going to wrap up. Couple of them questions are about amending your lease. You are always allowed to amend your lease if you can both agree. You can't do it by yourself. There's no right to amend your lease by yourself. There's no right for you to force your landlord to amend the lease. The lease is what the lease is. You signed it, it stays. The only way it changes is if you sign an amendment to change it. That's it. So if one question about pennies, and then another question about only opening, 25%, that the landlord can come back to the table with you and sit down and renegotiate that lease with you, given the circumstances. But it's very unlikely that they have to. So in leases where I've had tenants in malls, when there's a big anchor tenant. So let's say Publix is a big anchor tenant. JCPenney's is a big anchor tenant. Dillard's. These are big anchor tenants. And the rent that landlords can charge when they have an anchor tenant, all the businesses beside the anchor tenant benefits, because all the traffic is coming into the anchor tenant, and there's a small business here, I'm going to shop here too. So rent goes up. If the anchor tenant leaves and is not replaced, then there's not as much traffic, right? It doesn't necessarily mean that the landlord has to renegotiate with you unless it's written in your lease. Mm-hmm. So a lot of times, if I'm negotiating tenants that are going to have an anchor tenant in their shopping mall, I say if the anchor tenant's gone, then our lease drops, our lease rent drops, or some other types of rights and benefits. Because if we don't have the anchor tenant there, why am I here? I could have been across the street paying 75% less rent. So it all depends on your lease. If you've got an anchor tenant that has left or is shut down permanently. So office condo associations are completely private matters as well. Those are also governed by, Mary here, expert in homeowners associations, condo associations, having sat on the board of probably more than you wanted to. So you want to answer that question? How it says, how does this discussion relate to an owner in an office condo, many office condos here, who asks for a deferment of association dues? Is there standard language that should be used for repayment agreement?
Well, so, and I would say I have a lot of knowledge about condo associations and residential scenarios, especially since I live in one. And the business office parks work a lot the same way in that you have governing documents for the office area as a whole, just like you would in residential. I don't know if the business office condos may be a little more savvy than your residential ones and maybe more understanding and willing to work with people. I find that residential associations typically are not. But in a business office condo, I would imagine that, multiple tenants are facing the same issue right now. And so it would make sense, I think, for the board of that condo association to maybe set up some sort of a town hall or something for the tenants to speak with them about some issues. While the owners of each individual unit are probably different, it may be something that the board of the association generally, though, might want to address to everyone. But the association is going to have the final say over whether they are going to accept any sort of deferment let me back that up. The owner of the condos will have the final say in that. However, the board may be able to facilitate working with the owners to then work with their tenants if the owner is not if the owner is the landlord and not the tenant. That didn't come out exactly right.
It did. It made sense because there's so many variations of what that. I think the bottom line is, there's no magic language that needs to be used. It's really a matter of negotiating. Again, it comes down to negotiating with the people who are making the decisions, and there's no way to force them to do it. But hopefully, as people start realizing their circumstances and what this all looks like, they will willingly come to the table and talk to them, because depending on the governing documents of any office condo association, there could be consequences for not paying the dues, so definitely speak to them again as if you're speaking to the landlord as well, and try to work something out on that. Well, I know we're out of time, and thank you, Mary, for spending an additional time with us. I know we had some technical difficulties at the beginning, and I hope we've answered everyone's questions. There's many, many more topics I had on my list that we did not get a chance to do. So if we decide to do a part 2 of this, I'll let everybody know. Everybody who's registered will get a recording of this. I hope that you are able to work with your landlords on at least coming up with some solution, even if it's just a slight relief, that could be helpful. And keep trying, keep working, because I will tell you, landlords who were approached in March and said no are starting to rethink their answers now, because now they have more information and they're seeing what's going on. Because some people, tend to put blinders on and say, no, this is going to be okay. This is going to be okay. It's all going to pop back up. Now might be realizing that it's going to take a little bit longer for their tenants to get back in than normal. And so definitely work with your landlord and keep trying. Don't just, the silence, like Mary said, silence is deadly. Make sure you keep talking to your landlord about it in a way, in Chris's point, in a way that is not, I'm not going to do this, you need to deal with it. It's more of like, this is what's going on with me. I want you to understand where we sit with this, and let's see what we can do to help us stay in business and still meet our obligations to you, because we want to meet our obligations. Thank you all for coming. I think, Mary, did you have any last thing you wanted to say?
No, this was great, Laurie. Thank you so much for putting this together, and thank you, Chris, for your input and for all of the work that you're doing on the government end. You and Laurie have really, I think, gotten ahead of this as much as you possibly can, because at least as it sits right now, I have not seen that many commercial evictions. So hopefully, talking about this and bringing it all to light can maybe get ahead of that, and everybody will be more understanding, and we can get back to work, in time.
Hopefully soon. Hopefully it's in some form soon. And again, if you want to share your story, please send me an email. We are collecting details and stories, because those are so important to be told, so that we can see if there's some other government help that can be coming your way. All right, everybody, have a great rest of your day. And as always, reach out to somebody if you need help, and stay healthy and safe. Bye. Thanks again, Chris.
Thank you.
Bye. Thanks, Mary.
Thank you. Take care.